I rise to oppose this bill because it both makes it more difficult for the state of Michigan to protect its rights and interests, and it creates a situation where government is likely to intrude and impose on private citizens' interests in this state. But before I get to all those problems with this bill, I want to first speak as to why this legislation is unnecessary to advance the interests that the proponents of this bill claim it's designed to do. Historically, there's been a difference between an intervening party in an action and a party that is interested as a matter of good public policy or the rights and interests of others. An intervening party has historically been allowed to intervene only when its interests and rights are at risk. This legislation would allow a state legislative body to intervene, when in fact, this legislative body and the constituent legislators of this body will have very little direct material interest or rights that are affected by the situations that the proponents of this bill imagine. In fact, this legislation seems to understand that in the sense that it specifically refers to this legislative body intervening in order to protect any right or interest of the state as opposed to its own rights and interests. That flies in the face of many years of case law about when intervention is legitimate. And while this body and the body at the other end of the building may have relevant opinions on what's in the interest of the state, there is already a mechanism for that. It's called filing an amicus curiae brief, a friend of the court brief. That can already be done without becoming an intervening party. Number two, this legislative body can already intervene under existing law so long as it has the permission of the court. And number third, if in fact the proponents of this bill are concerned that some future attorney general may not intervene on behalf of the state, this body and the Senate already have the ability to direct the attorney general to intervene on behalf of the state of Michigan. And so all of the supposed rationales for this bill, frankly, don't make sense, are not supported by the history of case law, and are outright illogical. Unfortunately, this bill is even worse than that, though, because not only is it not necessary, it actually sets back the interests of both the state of Michigan and the interests of individual private parties in this state. The first way in which it does that is it creates confusion about who's representing the state of Michigan and who's representing the rights and interests of the state of Michigan. Not only might a legislative body take a position different from some future attorney general or a future governor, but this legislative body, the state house, could be an intervening party on one side of a lawsuit, while the Senate could be an intervening party on the other side of the lawsuit, both claiming to represent the rights and interests of the state of Michigan. One can imagine a finder of fact or a determiner of law in a lawsuit being confused about what the actual rights and interests of our state are under these kinds of circumstances. And so this legislation opens the door to different people squabbling amongst themselves about what the actual rights and interests of our state are at precisely the moments when it's most important for us as Michiganders to speak with a coherent, unified voice on behalf of our state. Secondly, while legislators have, I think, important and relevant insights into what they intended with legislation that they voted on or that they themselves crafted, this legislation does not limit a legislative body's ability to intervene simply in reference to legislation that was crafted during that same session, during that same term. If it did that, there might be a logical rationale for this legislation. But in fact, this legislation would allow a legislative body to intervene in a lawsuit and express its view as to the legislative intent behind a bill that was enacted decades or centuries ago. Something that a current legislative body has no more insight into than anyone else in the state of Michigan. But worst of all, this legislation tramples on the rights of private citizens. Unlike the legislation in Utah that's been cited and the legislation in other states, there are no details in this bill about when and under what circumstances the legislature can intervene. And so if, for example, a future Speaker of the House had a neighbor or a family member who was involved in a civil lawsuit, we could have a situation where this legislative body would intervene on behalf of a private party claiming that it's in the interests of the state. And so this legislative body is trying to put itself in a position today where it could tilt the scales of justice in a matter of private litigation between private parties in favor of one private party and against the interests of another private party. Similarly, this legislation would allow a legislative body to intervene at any time during a lawsuit, meaning that it could intervene late in a lawsuit, thereby delaying the resolution of that lawsuit, requiring private parties to incur additional costs, and judges would have no ability to prevent that from happening because this legislation takes away that judicial discretion. So in short, this legislation is an example of government overreach, an example of government overreach that tramples on the rule of law and puts the legislature in a position where they are likely to intervene in matters that actually impose undue governmental burden on private parties. And so one might reasonably conclude, everyday citizens will reasonably conclude, given the unnecessary nature of this legislation, given the fact that this legislation makes it harder for the state of Michigan to defend its interests, and in fact, harder for private parties to defend their interests, and because of the timing of this legislation, that this legislature was motivated out of a partisan power grab. Regardless of whether or not that...
I'm going to ask you to refrain from impugning motivations on this legislation. Please keep your comments limited to the legislation itself. Thank you. The chair recognizes Representative Greimel.
Regardless of whether or not that is in fact the motivation of this legislative body, the fact that reasonable citizens will conclude that will erode people's faith in government, increase cynicism at exactly the time when we should be increasing people's faith in government, we should be uniting this state, and we should be increasing people's belief and faith in the rule of law. I urge my colleagues to oppose this bill based on the protection of private property interests, based on the preservation of the rule of law, and based on the protection of our state constitution. Thank you.